Good afternoon and welcome to today's program that will review privacy requirements and implications for your business, including the European Union's General Data Protection Regulations, or GDPR, and the recently passed California Consumer Privacy Act, or CCPA. Today's presentation is brought to you by the Pacific Northwest Defense Coalition and Schwabe, Williamson Wyatt. First, I want to confirm all those joining us online can hear okay and see the screen. Just type yes in the question field if you're all set. Great, thank you. Please feel free to use this same field to ask a question at any time during the program today. Just type your question in the GoToWebinar dashboard and we'll make sure to relay that to our speaker. In addition, on your dashboard, you'll see a Handouts tab. Under this tab, you'll see a copy of today's presentation, relevant white paper authored by our speaker here today, as well as a list of upcoming PNDC events. We are very pleased to have Cecilia Jeong from Schwabe, Williamson Wyatt Law Firm joining us here today. Cecilia represents a variety of clients to help with their contract drafting, entity formation, conversions, mergers, and acquisitions. Cecilia brings an entrepreneurial spirit to her corporate practice, allowing her to view issues from clients' perspective to provide the most value while best meeting the client's needs. Cecilia, I'm going to go ahead and turn things over to you, and I will remind people to please ask their questions. This is a great opportunity to speak to an expert on this. Just type your questions in the dashboard at any time. Cecilia, please begin the presentation.
Thank you so much, Kate. Thank you everyone for joining me. I'm super excited to talk to you. As Kate mentioned, we will be talking about the GDPR and the California Consumer Privacy Act, which I'll be referencing as CCPA. And let's just dive in. Okay, so what are we going to talk about? So we'll talk about, go over a brief overview of the laws, the background and intent. That's actually very important to understand sort of the spirit of the law. This privacy is a growing field. We're actually quite in the primitive stage of privacy regulations globally. And so we'll see a lot of changes in the near future, and we'll talk a little bit about that. Then we'll review both the GDPR and the CCPA and do a comparison. So we'll go over its application, talk about the rights of individuals that it creates, and talk about how those laws address security, and then review disclosure requirements. And then after that, most importantly, we'll talk about 7 key steps to getting into compliance with these laws. Okay, so first, the GDPR. I'm assuming probably around early May, early May, maybe late April, everyone got a bunch of emails saying, hey, we've updated our privacy policy. That was because there's this new law called the GDPR that was passed in the EU, and it's the first of its kind globally. It's a sweeping law that regulates the collection and processing of personal information about any individual in the EU. And one misconception is that it applies to EU residents only, and that's actually not the case. The way that the law is drafted and its intent is to apply to anyone that's physically in the EU. So if you're a US citizen that is traveling in the EU and your IP address tracks back to you in the EU, then you technically have rights under that law. And it stems from the belief that privacy is a fundamental right, just like what we believe in our Constitution, the right of free speech, the right to religion. This is what the EU believes is a fundamental right. Now, what we saw after the GDPR was that other nation states were looking at the EU as an example, trying to figure out, well, how do we regulate privacy in our country? And the US is no exception. California generally tends to do its own thing often, and the privacy space is no exception. California has led in pretty much every privacy regulation that we've had. They were the first to pass the breach notification laws, and now all 50 states have their own version of the law. So what we saw recently on June 28th was that California passed the first of its kind Consumer Privacy Act. This law was passed this year, but it'll come into effect January 1st, 2020. There is actually a recent amendment that gives about a 6-month expected sort of grace period after 2020, but that is also subject to change. This law was passed in response to a ballot initiative proposing even stricter regulations. It actually was very hastily drafted. I believe it was drafted in a matter of 4 days. And as a comparison, the EU took years to draft. The nation states were in meetings forever about it. Privacy is not an easy space to regulate. They did this, California did this because there was a ballot initiative that had gained traction, about 600,000 signatures of Californian residents demanding regulation of privacy. And the legislature basically went into negotiations, and there was a deadline that if they didn't come up with their own law by this deadline, then the ballot initiative would move forward. Feeling under the pressure, the California legislators went into an emergency session, drafted this law, and this is the result. I call this, it's GDPR tailored with a twist. It's pretty much a smaller version, more condensed, not as expansive, but it has its own particular twist to it that the GDPR doesn't have, and we'll talk about that. Okay, just a heads up, my slides do have a lot of words, but it's because there's just so much to know. We'll talk about the applicable businesses. When you talk about the scope, it's important to know whether these laws even apply to you. For the GDPR, we'll start there. It's for any entity that's organized in the EU. If you are based there, if you are incorporated there, then it's going to apply to you. Also, it applies to businesses that are not organized in the EU if you're collecting or processing personal data related to offering goods or services in the EU, or you're monitoring behavior of anyone in the EU. So anyone that's doing targeted advertising, that's a big one. It's hard to track whether your consumers are physically in the EU, but this law kind of anticipates that you're going to need to figure that out. It also applies to controllers and processors. This is sort of a new concept that we haven't seen in this space, and controllers are the ones that are actually asking for your information. So if you go on eBay, right, and you're trying to buy something and they ask you for your information, your name, your address, they are a controller. And then the processors are anyone that encounters that data on behalf of a controller. So if anyone that is processing payment information for something you can buy on eBay, anyone that's deleting that data, storing that data, that would subject you to the law as well, directly. And then there's no restriction on commercial use. So generally in the United States, generally speaking, privacy laws are really focused on commercial use of personal data. So that means that you're making a profit off of it, or it's related to something you're buying, selling, that type of thing. But here it's not necessary, that restriction isn't built in. So for example, if you're a nonprofit, in theory, there are a lot of ways that you could be applicable to that law, or that law could be applicable to you, excuse me. Okay, moving on to the California CCPA. So this is where it's sort of the tailored part of it, is that it applies to for-profit businesses, and it has to meet a certain threshold test. So there's sort of 3 buckets here. The first bucket is your annual gross revenue is in excess of 25 million. The second one is if you share personal information of 50,000 consumers, households, or devices. Now that's an interesting concept here, the devices part of it, because you think about how many devices that you as an individual have. And then the third bucket is if you're making 50% or more annual revenue from selling personal information. Now what we're seeing more and more, and this is a concept, is the idea of big data. Your data is becoming your commodity, or a commodity. And the law is really trying to put its bears around, or get a grasp of that and make sure that that is encompassed in its law. It applies also to any entity controlling or under the control, or that shares a common branding of an entity that falls under the purview of this law. So what this is trying to get at is any sort of parent company or any entities, sub-entities that work together under one brand. So, all of the Google sub-entities, for example, so that they don't want to specify just one specific entity, but they're really looking at the eye of the consumer. What does the consumer see when they encounter your business? And then again, it applies to commercial use. It's a variance of GDPR from GDPR. Okay, the second big bucket. So personal information. How do they define it? Because if you don't have personal information technically under the definitions of these laws, then does it really apply to you? Maybe, maybe not. GDPR, their definition is any information relating to an identifiable natural person, which under the law they define as a data subject. This is interesting. It's quite broad. And what the GDPR also does is identifies special categories of data. In the United States, we would think of special categories of data as your social security number, payment information, healthcare. Our federal regulations are specific to what we define as personal or sensitive data. But under the GDPR, it's racial, ethnic origin, political opinions, trade union membership, and criminal convictions. And those are just examples of some. It's not the full list. So you can see here already that the way they see personal information of what needs to be protected is just slightly different than what we see here in the US. Under the CCPA, personal information includes any information that identifies, relates to, or could reasonably be linked directly, indirectly with a particular consumer or household. This is also interesting. It's kind of a twist here. It's not just talking about individuals, but also a particular household. So that implies physical location. And there's an exclusion, big ones. It's de-identified or aggregated information, and then certain federally regulated data. That's a recent amendment to the laws. So certain healthcare information, certain financial information, if they fall under the purview of HIPAA or Graham-Bliley, then it's excluded under CCPA. That is very particular though, and that's going to be super fact intensive, because even if the data falls under those laws, but what you're doing with it does not fall under those laws, then it puts you back into the scope of CCPA. Some three key sort of types that I want to highlight here. Obviously, we're going to think about the basic stuff. Your first name, date of birth, address. You really need to think about that. Second one, IP address. That's a big one that people don't really think about. And CCPA identifies IP address specifically as something that they consider personal information. GDPR does not. But the way that professionals have been interpreting the GDPR, it's pretty clear now that you should assume that IP address is included. And then your background checks. If you are running background checks on employees or independent contractors in the EU, that's a big one. That is, they're not a consumer, but it's still personal information that you have, and it's special. It falls into the special categories of data. So that's something you're going to have to protect particularly, and think very specifically about. Okay, so individual rights. One new concept that we're seeing with privacy is that they want the consumer to be more in control of their information, where it goes, who has access to it, what they're doing with it. GDPR creates 7 categories of rights. One is the right to access. So an individual should be able to access easily what information a company has about them pretty much at any time. And then the second right to rectify. If a company has information about you that is not correct, then you have a right to be able to fix it. 3, the right to be forgotten. You have the right to ask a company to delete all of the information they have about you. Now, this one is usually where everyone goes, hold on, wait, what? There's certain basis on which an individual can request this. For example, if the company doesn't need it anymore, you did a one-time transaction with them and you don't plan on doing any more, buying anything from their site anymore, or maybe they've changed their focus and are offering a new consumer product that you're not interested in, then that's one of the reasons. It's not an unlimited right. So they can't just do it at any point, but there's just certain enumerated reasons on which they can request that. The right to restrict processing. So oftentimes processing includes sharing data. So if you work with a third party that is supposed to delete your data or, I don't know, go through some other process, help you do that, then technically a subject under the GDPR has a right to be able to restrict that. I think generally it's more focused on sharing data, but you just should be aware that it's there. The right to data portability. This is an odd one. This basically means that you have the right to request a company package your information in a way that's comprehensible and send it to another third party that you have approved receiving that data. It's an odd one. It's interesting. I don't know how much this is going to be used. I think this is one of the rights where everyone's kind of looking at it from a side eye, but it is there. And then the sixth one, right to object, also similar with sharing. You have the right to be able to say, no, do not give that new marketing company or share my data, sell my data, don't do that. Usually that comes in the form of an opt-out. So opt-out is if you have to unclick a box that says, that's automatically clicked, that says that this company, if I accept cooking, yes, that this company can share my data. If you have to click off of that box, then that's an opt-out. If the automatic option is that it's unclicked and you have to click in order to be able to approve the company to do that, that's an opt-in. So generally, the sort of good practice is an opt-out. We'll talk a little bit more about that. That might have been confusing. And the seventh one is the right to individual decision making. This is just the concept that individuals have a right to be able to decide what happens with their data. And then under the CCPA, again, this is the tailored part, right to transparency, very similar to right to access. The consumer should be able to see what information you have about them. The right to be forgotten, very similar to the right to be forgotten in GDPR. And then the right to notice and opt out. So there are certain disclosure requirements that you need to make under the CCPA, including the rights that they have under this law. GDPR also has a similar concept. And opt out. So that's the sort of the combination of the restrict processing and the right to object. And California is particular in that you need to have two methods to be able to opt out. And it needs to include, if you have a website, an entirely separate link that someone could go to click to opt out. And then the right to no discrimination. If you decide to opt out, then a company can't discriminate you, for example, charge you more if you decide that they can't share your information with a third party. Again, these rights are also restrictive. They're not unlimited. There are certain bases, there are certain tests that you have to meet, but the concept should be embedded into the way you develop relationships with consumers. And then, as I mentioned, you have to have two methods to submit information requests. At minimum, it's a toll-free number and a website. So if you want to access your information or if you want them to delete your information, then you need to give the consumers two ways to do that. Operationally, I think that's a little bit difficult. So there's a lot of companies, we work with a lot of mid-sized companies where they say, we don't even have a team or a dedicated individual to deal with data. And this, I think, is going to be very disruptive in the market. As data becomes more and more transient and as it becomes more and more important, like a commodity, companies are going to start needing to develop that into their operations and really build it in. Okay, and the time to respond. Under the GDPR, again, the time to respond actually varies depending on the right and depending on the circumstance, but GDPR generally is without undue delay, and then you can ask for a 1-month follow-up deadline. 2, if it's extended, but you need to tell the consumer that it's going to be extended and why. And so I think the focus here is that the agencies want to see that you're trying, right? That you're communicating with your consumer, telling them, look, we're going through the process. It takes a little while. We have a backup server in Ethiopia, whatever it is, and it's going to take some time. But if you're communicating with the consumer, that's, I think, what the spirit of the timeline is. And under the CCPA, it, again, depends on the right, but you generally must deliver within 45 days of receiving a verifiable request. Now, that's an interesting concept here, the verifiable request. And this is something that we anticipate that will be interpreted in time, because, the question is, what does a company need to do in order to verify the request, right? Do you need to ask for social security number or whatever it is? And what type of security risk does that cause by even going through the process of verifying a request? So that, I think, needs to be broken down. The law really does not interpret it, and it's not very clear. Okay, the next big concept is security. So I like to think of security as either, with respect to laws, either reactive or proactive. And that line right here is where a breach occurs. So laws that require you to do something before the breach occurs, and then laws that require you to do something after a breach occurs. So it's a little backwards here, but we're going to start with the proactive. Now, proactive, GDPR says that you must implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk, including as appropriate, and then it offers a number of examples. Sorry. The first thing I want to highlight here is the technical and organizational measures. So technical means, for example, like security controls, understanding when a breach happens in your system. And then organizational measures are having training, making sure that your employees, it is embedded into their processes, their trainings, they understand what to do on the day-to-day. So you can see that these laws are trying to grasp at that there's multiple ways. You can't just say that you have these technical measures. You can't just adopt policies and then not implement them. So here are some examples that this law finds to be appropriate. Pseudonymization and encryption, ensuring the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. These keywords, confidentiality, integrity, availability, resilience, those are keywords standards organizations have come up with regard to proper security programs. So you'll see, I'm sure you'll see that a lot if you start looking into security controls, getting assessments done, risk assessments done, et cetera, et cetera. And then restoring the availability and access to personal information in a timely manner in the event of a physical or technical incident. So oftentimes what we've seen in the past is when a breach occurs, you just pull your entire system off of the network, and then you're sort of not connected for a time being. Well, this law is really looking at how long is it going to take you to restore all of that. Because if you take it off the system, then consumers no longer have an idea of what you're doing with the information, what happened with it, where is it? And so this law wants to know that one aspect of appropriate technical and organizational measures is your availability to pull it back onto the system. And then regularly testing, assessing, evaluating the effectiveness of security measures. That is huge. And that should be done and definitely baked into your operations. That should be an annual, semi-annual process that you endure, that to make sure that things are working. Look, like technology is changing, companies are changing, the way we use data is changing. And so these processes, or whatever measures you have in place, should also be adapting to the changes that your company faces. Now, CCPA also very similar. They look at reasonable security measures, procedures, and practices that are appropriate to the nature of the information. Now, all of this is to say that these laws are using words like appropriate and reasonable. All of these measures are not going to be reasonable or appropriate for every type of business. So this is a risk assessment here, and it's very, very fact intensive, and it's industry specific. So what we anticipate is that there's going to be a lot more industry standards that are developed as these laws get interpreted, enforced. I think we're going to see a lot more of what is actually appropriate and reasonable in certain spaces. Okay, the security of personal information. Here, this is the reactive part of it. So after a breach occurs, what do you need to do? The GDPR is sort of revolutionary in its own. So it requires notification to supervisory authorities. There are a number of them throughout the EU. There is not one currently in the United States, but if you fall under the test of the type of businesses that GDPR has, then technically the supervisory authorities in the EU has jurisdiction over you. So the controller, whoever is asking for the information, must notify these authorities, within 72 hours. So that 72-hour period is what I meant by revolutionary. That is so fast. Most of the time in the United States, these laws are, at fast as like 30 days, 45 days, something around there. 72 hours is extremely quick. And it also comes with the question of you need to know that a breach actually has occurred. For example, if a controller has multiple processors, right, the third parties that are doing advertising, whatever, on behalf of them, and a breach occurs in the processor system, then the controller is required to notify a supervisory authority within 72 hours, meaning that the processors have to notify the controller within 72 hours. So if you think about the implications of that, in your processing contracts, vendor contracts, there should be a provision that requires that gives you some sort of safety net, and that needs to be part of the discussion when you engage with them. And then, as I mentioned, yes, processors need to notify controllers without undue delay. And then controllers are also required, processors, both of them are actually required to document breach. And then you also need to notify data subjects, and this is a very specific term to GDPR, if it's likely to result in a higher risk to rights and freedoms of individuals or data subjects. And then, and again, that risk, the way they define higher risk to the rights and freedoms are slightly different than the CCPA, because remember, things like criminal record and your political beliefs, those are sensitive information, so the risk is technically higher. And then also the time to do that is without undue delay. Under the California Act, the CCPA actually doesn't address this, but there are other California laws. I thought I'd just throw these in here for reference. You have to provide notice of the breach to individuals whose data is affected within the most expedient time possible and without unreasonable delay. Again, fact intensive there. And then the second one is notice to Attorney General if 500 or more individuals are affected. And that sounds like a lot, but it's not. I'm not sure how many residents live in California, but there are a lot. In Washington, for reference, I'm from Seattle, there are 7.2 or 7.4 million people that live in the state, so 500 is nothing. And then also the Attorney General's turn around then and publish that information. So in whatever state that your company is in, you can find a list of how many companies have reported. Okay, this is a big one. What disclosures must businesses make? So in these really fun policies called privacy policies that most people don't read, I read them, there are certain disclosures that you need to make, and part of that is what rights that they have. But then there's a number of other categories, so let's go into that. GDPR, it's the identity and contact information for the controller, the period which personal information will be stored, or the criteria that will be used to determine that period. The third one is information about data subjects' rights and how to make requests. For example, the right to withdraw consent or the right to lodge a complaint with a supervisory authority. You need to let them know that they have that right. And the fourth category, data, is necessary to enter into or perform a contract and the consequences of not providing that data. So those are statements like, we need to collect your data, and if we don't, then this may affect your use of our website, right? Like the cookies notification, that's an example. Or if you don't give us your address to mail products, you can't buy products from us because we don't know where to send it. And then the next bucket is existence of automated decision-making, including profiling. If you are tracking an individual or you're doing targeted advertising, then you need to identify that. And so sources of data collection. If you are buying information from other companies, personal information from other companies, databases, things like that, then you also need to identify where that is, who those folks are. Oh, excuse me. Oh. Sorry, having some technical difficulties here. There we go. That was supposed to be a surprise photo. Okay. The last one is information based on request. So what information they can request to get from you. CCPA, also some similar ones, information about data subjects' rights and how to make the requests. Again, the minimum 2 methods here, that's important. And then the do not sell my personal information opt-out. That is a separate tab that needs to happen. So just like you have a button on your website on the bottom, oftentimes that say, here's our privacy policy, you need to have a separate button that says, do not sell my personal information. And then the information based on request. So categories of data collected or sold, categories of sources of data collection, how the data will be used, and to whom the data will be shared. The data will be shared or sold. Okay, so this photo, yes. So this is the look that I often get when I do presentations like this because it's so overwhelming. How are you ever going to be compliant? Oftentimes, compliance entire overhaul of your system. There's so many requirements, and it's a moving target. And in recognition of that, compliance is, first of all, very difficult. And just like the movement of these laws and the transition of these laws, your company is going to have to be malleable in its compliance strategies. But there are some key steps that will help you sort of get to that point, to get to compliance, as these, to the point where they get interpreted and we really understand what they mean. These steps will help in move you into the general direction. The first one, this is big, and this is both for generally in compliance strategies for security and privacy, is you need to do a complete audit of your data and map out data transfers. So these are the questions that you should be asking. What data is the business collecting and from who? Who is doing the collecting, and are they doing it on behalf of themselves or for another entity? What is the business doing with the data? How long is the data being stored? And can the data be easily accessed or deleted? These are if you are trying to develop a strategy and build out processes, do trainings and all of that stuff, you need to know what you're working with. This is building out the universe of what you have to work with. And I think this is probably the biggest step and the most difficult one. Often we work with companies that don't know what sort of cookies, web beacons, IP addresses, what type of things that their websites are collecting. And often they have consumer information of prior customers, dating all the way back from the beginning of the company. And whenever I ask them, what do you do with that data? They say, we don't do anything with it yet, but we might do something with it. Maybe we'll market to them later. That's not a valid reason under these laws. And that's a practice that you kind of have to nip in the bud. Okay, second step. Ensuring that your company has at least one legal basis for every processing activity. These are categories that are built into the GDPR. The idea is that companies need to have only the data that they have a valid reason of having and keeping. So this is, for example, the data subject has given consent. So the person has told you, you can have this data. Usually that's tailored to a specific reason, but that is valid. Pursuant to a contract, that's another big one. So if someone buys something from you and you need to ship it to them, you need to help them, customer service, they ask you a question, you need to answer it. those are generally valid contracts. And that's probably the biggest category that companies are using as a basis to keep data. To comply with legal obligations, that's another one, obviously, that's pretty much baked into every US law and EU. And the fourth one, necessary to protect vital interests of a natural person. That's important. The next one, necessary to the public interest or an exercise of official authority or controller. So if a data authority comes to you and says, we need to know what you have, and therefore you need to keep certain types of data and do an assessment of it. Well, then for the length duration of that investigation, you need to keep that data. And then the last one, it's necessary for a legitimate interest of the company that does not override the rights and freedoms of the EU data subjects. That's the other bucket that a lot of EU-based companies are relying on. And it's a little bit tricky. It depends on the type of data that you have. Again, the more sensitive types of data that you have, the harder it is to make this claim. But one example I give is for prior employees. So obviously you have certain restrictions that you need to keep prior employees' data in case they sue, that type of thing, right? But we worked with the company and they had the information of prior employees all the way from the formation of the company, which was like 30 years back. There's no need to keep that. And especially if those employees are out of the EU, then particularly do not keep that. It's hard to make that argument at that point. The third one, implement company practices or policies and procedures to allow data subjects to exercise their individual privacy rights under the GDPR or CCPA. So those are both internal and external, meaning that external provide what steps that the individual needs to take in order to exercise their rights. And then also internal is is your company going to deal with that? Who are those requests going to go to? Who is responsible for making sure that those rights are carried out? And how does that impact the other processes of your company? And then you need to consider operational and IT considerations. If there is a separate button on your website, where does that lead, right? How does that information get to your division or point person operationally? And the third one is consider your third-party relationships. Who are all of your vendors? Who are your independent contractors? Who has access to this data? Who's doing things for your company that involves working with this data? If you get a request for information to be deleted, there is a responsibility on you to tell your vendors who also have those information to delete that data because they have it as a sort of representative for you. So you need to think about how that works operationally as well. And then the fourth one is adopting a privacy policy applicable to the strictest standard and make it available at all data collection points. So this is kind of a generalization, but because there are so many different privacy laws, in the United States, for example, breach notification, there's 50 different laws. California has an online privacy law. New York is developing one. There's a number of laws floating around, and it's really difficult for companies to be able to be compliant with just the laws that apply to them. Because, for example, if you have an online presence, then likely you have consumers reaching out from all 50 states. So what we generally say is work with the strictest standard and develop a policy that way. And when you do that, then it sort of puts everything else within that purview, and you are going to be more likely to be compliant with the laws that apply to you. So here, generally, we say it with the GDPR. Obviously, California, there are some particularities, but GDPR at this point is the strictest standard. Now, the fifth one, put in place data processing agreements, contracts with all third parties that handle personal data for the company. And this can include policies. Like, for example, if you go into Google Analytics, is a company that a lot of our clients work with. And if you go through Google's policies now, they're pretty much processing agreements. I mean, they talk about in and out what they do with the data, they aggregate, they, what sort of individual rights are there, what company rights are there. It is pretty built out, and that's kind of the model we recommend that companies take, especially ones that have a lot of third-party agreements that work with a lot of vendors. Each one is sort of a risk. It's a risk point, right? It's a vulnerability, both from a security standpoint and from a privacy compliance standpoint. And so, your agreements should reflect what type of requirements each party has to abide by, and what the sort of repercussions there are if they don't. And then 6, design and integrate appropriate data protection and security. This is starting with an assessment and then building in certain controls, making sure that your employees know what to do if a breach occurs, how to identify a breach. Those are all the things to be considering when you're designing and integrating. And the design part is that it has to be particular to your company. Not every company is different. They work with different data, they work with different software, and so it's really going to have to be a fact-intensive conversation when creating a customized program. And then the 7th one is adopting and implementing data breach response procedures. This is huge. Again, all 50 states have requirements, and oftentimes the repercussions are that, you can be subject to fines, attorney generals can go after you, and they have before in the United States. And it's really important to understand what those requirements are, and then also to be able to educate your employees on what needs to happen. And it needs to happen, you're often in a timeline and a deadline. So you want to make sure that your processes reflect the urgency of it and your employees know what to do. Okay, and actually, I think that's it. I sped through that a little bit quickly, but if anyone has any questions, I would love to take them.
Great. Thank you so much, Cecilia. Really appreciate it. We do have a few audience questions, and I'll remind all our audience, if you'd like to just type those in the question tab, we will definitely get those to Cecilia and get to as many as we can. One question we have, if someone's capturing personal data in order to fulfill a warranty, maybe on a serialized product, can they warn the consumer if they ask to have their data removed, that will invalidate their warranty because they won't be able to tell if it's a counterfeit product or not?
Yeah, so that's actually one of the exceptions built into some of the rights. Generally yes, and also the warranty is probably part of a contract as well, and so you have a valid right to keep that information. But if the consumer chooses to not do that, and the risk of that being that the warranty will end, then I don't see why that would be an issue. Again, it's going to be fact specific, and each policy is a little bit different, and it depends on the product as well, I'm sure. But yeah, that's a concept that the laws actually anticipate.
Right. I know the California law is new. What changes do you anticipate occurring with the CCPA?
Yeah, so the CCPA again is really hastily drafted. Terms are inconsistent. It doesn't make any reference to other California laws, which is wild because there are a number of other California laws. And so I'm assuming that a lot of those will change. Terms will be clarified, references will be clarified, and I think actually the effective date is going to change. So there was a recent amendment, actually, I think passed this last week, that provided for a sort of a 6 months grace period. I think it's going to be a little bit longer than that. I think they're kind of underestimating how long it's going to take for these laws to be interpreted and really like for companies to understand them. It's quite disruptive, actually. And I think certain terms currently requirements are going to be interpreted. Like, for example, the 25 million gross revenue target, like does that include anyone that falls under that brand, right? Like, is it just that specific entity, or is it the entire brand of entity? Is the $25 million from revenue in California, United States, global? So I think those types of things will be clarified, hopefully.
Perfect. Here's a question here. What are some of the most important policies or procedures a company should adopt to be compliant with privacy laws?
So the first, obviously, if you have a website, then have a privacy policy. I really, really recommend not getting a boilerplate one from the internet. So there's a lot of programs out there that sort of spit out policies, and these policies actually need to be very specific to you, because if they are misleading or if they are false, then there's also other federal regulations where they can come after you for having a deceptive policy, like the FTC has done that in the past. So they do really need to be tailored to your specific business. And then other examples of policies that are important, data retention policies, that's important. Again, security breach policies, how to recognize one, what do you do after one occurs. I think those are probably the most important ones.
Great, thank you. Question here, are there de minimis exceptions to the GDPR? I hope I'm pronouncing that correctly.
Yeah, so I think what that question means is, like, if it's like a one-off transaction. Is that what you mean by that? Yeah, so if it's a one-off transaction, you only have, one, I can't even put a threshold on it, but you really don't transact in the United, or in the EU, excuse me. You're not offering goods or services in the EU, but you have like one contract, one order that comes out of the EU. Yeah, the law does recognize that those one-offs don't apply. However, how do you really define that? Is that one every 6 months? Is that one every 5 years? It doesn't quite build out the threshold that way. So I think there's some ambiguity there, but certainly it does at least anticipate some sort of de minimis.
Great, thank you. And how about, especially with the GDPR, because it is in effect, when should someone call their lawyer when they have a breach?
Yes. Well, when they have a breach, I would say you should probably call your lawyer before the breach. But as soon as you identify that a breach may have occurred, you haven't even clarified that yet, then you should engage a lawyer. So you should engage a lawyer, and then also engage some sort of forensics to determine what happened. And it's often, we would generally suggest that you get a lawyer first. It doesn't protect all of that information necessarily, but there is a stronger argument to be made that that could be attorney-client privileged information if you engage the lawyer first and then go into forensics. But again, that's very fact-intensive. I can't say that that's always going to be the case. Generally, if you have any indication that a breach has occurred, then engage a lawyer and then talk to sort of what you need to do on the technical aspect of it to identify whether a breach has actually occurred and then what happened. And then with regard to privacy, I would say that if you're starting to try and figure out your compliance strategies, what type of policies you want to pass, the earlier the better. Talk to your lawyer, discuss what it looks like for your company, what are the risks, and then see what measures would actually be appropriate for your business. Because it's not that you need to do every detail, comply with every certain requirement of every privacy law if you don't need to, right? So I would say the earlier the better.
Right. And one last question here, regarding the right to be forgotten. Mm-hmm. Is there any acknowledgement that that's kind of impractical with all the backup somebody could have that would include that person's data?
So what's really interesting is that it doesn't. Certain laws out there will have some sort of exception if it's unfeasible or unduly burdensome for a company to endure. But this law actually doesn't have that. But the other flip side of that is that there are only certain bases on which an individual can request that you delete data. So if someone is misappropriating it, or if they've gone outside of the warranty period and they're still holding your data for purposes that you haven't consented to. But technically, no, it doesn't recognize that there's an exception for technical difficulty.
Great. Thank you so much, Cecilia. We really appreciate you sharing your considerable expertise on this. Great information. I'll remind everybody on the handout slide, or under the handout tab, there's a copy of the presentation, a white paper that Cecilia and her colleague have written on these privacy requirements, or specifically on GDPR, I believe. That's a really good resource. We'll also have a recording of this presentation that we will send to everybody that you are welcome to share with colleagues, because I know this is really a big lift for teams, and good to have this information. I would like to remind people of a few other upcoming PNDC events. We will have a series of webinars on a few different government contracting issues, including bid protests and indirect rate, what strategies are right for your organization. We'll also have our annual EAR and ITAR Compliance Conference on October 3rd in Portland. That's a great annual event. We'll have tracks for those that are very experienced in ITAR and EAR compliance, as well as those newer to that, maybe new employees that need to get up to speed on that. We will bring a group of members to the AUSA show. That's the Association of U.S. Army shows in Washington, D.C. on October 8th through 10th. We do still have one booth spot in the shared booth. If you're interested, please contact PNDC. We will also have our annual dinner on November 13th. We are very pleased to welcome the Chief Technologist for NASA, as well as Rear Admiral Gray, the commander of the Navy's Northwest region. Lots going on. Please feel free to check out pndc.us for more information. And Cecilia, I would like to once again thank you for sharing your expertise and Schwabe, Williamson, Wyatt's ongoing support of PNDC. We greatly appreciate it. And I would like to thank everybody for joining us here today. A good start for your privacy policies at your company. So thank you so much. The webinar has now ended.
Thank you.